Slide your door shut.
Please, yeah.
Hello, Council. This is the Court Clerk, Amanda DeGaynor. Can I have everybody just start their video? I just want to ensure that we can see everybody before we get started here in just a few minutes. Thank you. Thank you, Mr. Thierman. Thank you. Thank you. Okay, it looks like we're ready to go. We'll be getting started in about 4 minutes. Thank you.
Okay, good afternoon, everyone. We are on the record in the Amethyst Payne versus Detr case number Civil 20-755. I'm Judge Breslow, presiding judge in Department 8 of Nevada 2nd Judicial District Court. We are proceeding this afternoon, as we have in the past, via the Zoom webinar platform, as allowed by Nevada Supreme Court Rule Subpart 9 and recent administrative orders of Nevada 2nd Judicial District Court. Court hearings being conducted through simultaneous audiovisual means are, of course, the result of the local, national, and worldwide COVID-19 pandemic. At this time, I invite members of the court staff, starting with the court clerk, to please identify herself from the record, as well as identify what county and state she is joining us from today. Ms. DeGaynor.
Amanda DeGaynor, Court Clerk, Washoe County, Nevada.
Thank you very much. The certified shorthand reporter, Ms. Zinn.
Solde Zinn, Washoe County, Nevada.
Thank you very much, Ms. Zinn. Counsel for plaintiffs, starting with Ms. Jones. Good afternoon.
Good afternoon, Your Honor. Leah L. Jones, plaintiffs, Washoe County, Nevada.
Thank you. Mr. Thurman, good afternoon. And Mr. Thurman, the familiar refrain in Zoom world, you're still on mute.
I apologize. It's a balance between not interrupting and talking when you're supposed to. Anyway, good morning, Your Honor, or good afternoon. Mark Thurman, Thurman Buck, for plaintiffs in Washoe County, Reno, Nevada.
Thank you very much. Mr. Whitney, good afternoon.
Good afternoon, Your Honor. Good afternoon, everyone. Robert Whitney today from Clark County, Nevada. Thank you.
Thank you, Mr. Ott. Hello.
Good afternoon, Your Honor. Greg Ott from Carson City, Nevada, joined by Counsel for Employment Security Division, Troy Jordan, Administrator of the Employment Security Division, Jeff Frischman, and Director Cafrata of Detr.
Thank you, Ms. Cafrata. Good afternoon. How are you today?
I'm good, thank you.
Very good. Nice to see you. Okay. Well, let's get right to it. Several things to discuss this afternoon. Number one, I apologize. I went back in advance of the hearing today and looked at the order the court entered back in September, and I noted a blinking typo. I think it was page 2. The order that in part had directed the state to pay the special master Guanasso's fees and costs, albeit at a discounted rate that he was charging, had inadvertently, while the ultimate amount was correct, the court had conflated the dates of the two different billings. So let's recall, there was an August billing request for July's work, and there was a September filed billing request for August work. So the court order entered in September granted and apportioned to the state 100% of the special master's fees and costs for the July work reflected in the August billing. So simply the corrected order was filed about an hour or so ago. One of the things we will do today is address, and certainly not a surprise to anyone on this call, the second of the special master's 2 billings, the one that was filed in September for work through end of August. So I want to talk about that, number one. Number two, I want to also ask what the status is of the mediation. I don't need details on participation levels, issues. I just want to know if that resolved some or all of this dispute. Presumably, if it had the latter, the court would have already known about it. 3, I want to talk about whether the appeal is still pending, what the status of that is, and presumably if the mediation was not successful, and if the appeal goes forward, this court is still divested of jurisdiction on anything other than auxiliary or ancillary matters. And then finally, assuming the court moves forward from this point, the question is, do the parties still ask the court to hold off on moving forward with setting a hearing on what was previously sought by the petitioners, that is, order to show cause, why the state should not be held in contempt for failing to fully abide by the court's prior orders. So that's what I believe we're here to talk about today, plus anything else that's on someone's mind, and perhaps the court has omitted something or is not recalling correctly the status of proceedings. So with that as background, my preliminary thoughts, let me hear from Mr. Thierman, please. If you could please address any of the issues the court has just spoken on, and then I'll hear next, please, from Mr. Ott and or Mr. Whitney. Mr. Thierman.
Mediation, unfortunately, was not successful at all, and or at least it resolved none of the issues. And we are pursuing the appeal, and there is an emergency motion very similar to the one that was previously filed, and a reply or a response, and a reply is due Friday. Yes, we wish to continue with the contempt.
Okay. That's straight and direct. Mr. Ott, you agree that the mediation was unsuccessful. You agree the matters are still on both the direct appeal and the cross appeal. There's a motion or there's an application to the Supreme Court for relief, a response, and a reply soon to be filed, and that this case should go forward. Again, to the extent of the court's jurisdiction under the context of a matter that's been appealed.
Oh, yeah, sorry, I was waiting to be unmuted. I was looking at the wrong portion of the screen. Yes, start with the obvious agreement. Mediation was not successful. Both appeals are still pending. Mr. Thierman accurately described the status of the pleadings before the Supreme Court. I guess the area we disagree with is whether there is a need for the contempt to go forward. We can talk a little bit further about the change in status since the last time we were before the court, but in summary, those are the two areas of agreement and the one area of disagreement.
All right, so let's talk about the contempt for a minute. You know, the petitioner has the right to ask the court to set a contempt hearing. At that hearing, it's the petitioner's burden to convince the court that the state, without legal excuse, has violated a prior court order. The mere setting of a hearing on an order to show cause why a contempt order should not issue is, while a close cousin, a far stretch from an actual determination on the merits. This is just the petitioner's right to seek the court's review of the state's activity to determine if there has been complete or close to complete compliance with the court order. And to the extent there has been less than complete compliance, whether there is justifiable or legal excuse for the failure to fully comply. Mr. Whitney, I'll give you a chance to add anything, and then I'll ask Ms. Jones as well if there's something that she'd like the court to know.
Just, Your Honor, I believe Mr. Ott and Detr will present information that there has been substantial compliance, if not actual full compliance with the court's order of mandate and what the court had ordered us to look at. Detr's put quite a bit of effort into trying to come into full compliance with that order, and I believe there is a witness up there today for Detr, one of Detr's administrators that is prepared to testify under oath to that. And thank you, Your Honor, for allowing me.
All right, thank you. You know, I really was not prepared to handle a hearing on the merits today, and I apologize for not making that completely clear. So to the extent people have prepared for that event and allocated their time and prepared to express their views and understanding and evidence to the court, I apologize if that was something that unfortunately will not be going forward today, but it will soon enough if that's the way that we are headed. So Ms. Jones, I'm gonna let you address the court. I'm fully expecting you to remind me that people continue to suffer and have not been fully yet paid all the monies that they're due. Do I have that right?
I won't remind you since you reminded all of us. Regarding the contempt motion, plaintiffs filed 2 contempt motions. Defendants answered one. The stay entered, so plaintiffs did not reply. I would remind the court that yes, plaintiffs would like to go forward with the contempt motion, file their response or their reply in support of, and set a hearing, regardless of the fact that defendants have argued that they have made substantial compliance. There's still the issue of substantial compliance did not happen on the date that the court ordered. So plaintiffs would like to go forward on the contempt motion, would like to set that for hearing, and would also ask the court if we're still allowed to file a response in support of that second motion for contempt.
Okay, so here's how I'd like to approach this. And again, this is preliminary, and if what I say, either side feels aggrieved or believes that the court should vary, tell me, and then I'll make it final. What I'd like to do is, by this hearing, unstay the case and give the state additional time to respond to the application for contempt sought by petitioner, and then agree on how much time the petitioners have to reply to that response, and then pick a date for a hearing. And I'll set out half a day. So we can either start at 9 in the morning and you'll have till noon, or we can start at 1:30 and you'll have till about 4:30. So I'll make sure I have full 3 hours blocked off. Now that hearing date, however, would have to happen after Thanksgiving. The reason is primarily, aside from the briefing and the time for the court to review and prepare, we are now today in the middle of jury trial number 3 in our second judicial district court since the pandemic shut down the courthouse. And this court, Department 8, will be presiding over a very serious criminal justice matter that's set to start on November 16th. That will be at least that week and might run into Thanksgiving week. In the run-up to that November 16th trial, the court has other matters that it needs to address. That's not for a moment suggesting that this case is not of critical importance to the court. It is. I've mentioned before my belief that I've tried to make myself available as issues arise in this matter, somewhat in the line of a concierge judge, so I can and monitor, oversee, and be available on very short notice. But the reality is, before this court would have time to set out a half a day and prepare for a hearing on a contempt proceeding against the state of Nevada for failing to abide by the prior writ of mandate, I would need at least until after Thanksgiving. So whatever date and time we pick, unfortunately, will have to be at the very end of November or more likely in the first week of December. Mr. Thurman, any thoughts in response to what the court just said?
Not directly. If the court remembers the declaration of David Schmidt, it had a list of, as an exhibit, of 20,158 unique applications with weeks claim not excess earnings, which I gather out of the 25,000 or so people that were included in the court's original order were not paid. And then some reasons why they were not paid, even though they had been started to be paid. And if this could be the roadmap for a revision of this and an updating of it, same process being used, I think it might expedite your hearing, because it becomes a legal argument whether this is in fact sufficient reasons not to have paid these 20,000 people despite the court's order. So I'm hoping not to have a lot of testimony. It's always fun, but may not be the most efficient way of proceeding.
Well, all right. So you answered a question I didn't really ask. And the question you answered was, what do you think is still an important issue for the court to focus in on at the upcoming hearing. And certainly it's not lost on the court that is a big issue, and that needs some explanation for the court to be convinced that there's a justifiable reason, if the facts show that, why those people weren't paid, or if they weren't, if they were otherwise encompassed by the court order. But in terms of giving the state additional time to respond to the motion for a contempt order, to give the petitioners additional time to reply, and then file a request for submission, and then set it for a half-a-day hearing, probably the first week of December. Does any of that procedural structure give the petitioners, heartburn that can't be addressed another way?
No, actually, I think that's pretty much what we need to have an update. I mean, the whole purpose of this is not the $300 or whatever fine that's first allowed, but to get these people paid. So if we have an update that says, gee, the 20,000 people got paid, having done a second run, there's only 5,000 that we started and stopped since then, and they're working on it. It's the court to decide whether that's sufficient compliance. But
Okay.
Yeah.
Mr. Ott, your thoughts on the way the court has framed this out?
A couple thoughts. First, I just wanted to briefly address something Ms. Jones said about the two motions for contempt and us responding to the second one. That was pursuant to a conversation we had at a prior hearing where we asked the court what to respond to, and I believe the court indicated respond to the second. So it wasn't an intentional omission of the first.
Understood.
With regard to the roadmap of the court, I don't know that I'd have to look at the order for stay. I don't know that you actually need to unstay the case in order to hold the hearing if you want to, but probably need to look at the order in more detail to decide whether I think that's necessary.
Well, the stay was to allow the mediation, but now that you've confirmed to the court, you went through it, it was unsuccessful. Maybe organically, I don't remember either, maybe organically the case is unstayed as to that. Mr. Thierman, is that your understanding as well?
Well, I reviewed your revised order, and because you dated it today, you have a 30-day stay from today actually in it. So
it's
one thing.
That order is non-protunct to the date that it was originally. Thank you for reminding me to say that on the record, but all I did was clarify a typographical
I know,
errors.
but when you redated it, which you should have done for today, which is when you signed it, it kicked in the 30 days. I knew you didn't mean that. I knew the other side knew you didn't mean that, but I did want to bring that to your attention that I don't know what's left of the 30-day stay. It's gone. But and now we all understand there's no new 30-day stay in. We're clear. That's fine.
No, so it's game on, right? It's game on. All right. So Mr. Ott, yes, you need only respond to the second motion. The state. So how much time would you like if we're looking at possibly a first week of December date for hearing? Can you fully respond within 20 days?
I think likely 20 days would be fine. I would like to ask for a little bit of clarity about what we're going to be talking about at the hearing, because I think there's confidentiality concerns when we certainly get into a contempt motion, which is whether certain people were entitled or should have been paid, or whether they fall into one of the three other categories. That may entail some sort of recitation of specific facts in their file. As we know, individuals who submit applications have confidentiality under 612-265. Not necessarily a problem for the named plaintiffs, because I think Mr. Thierman can waive that confidentiality on their behalf. When we get to non-named parties, we are either going to have confidentiality issues, or we are going to have to deal with that in some way where we're either talking about broad categories and we can't get into specific details. So I think I would appreciate a little bit of clarity with regard to what the court intends to look at in that hearing. And I think we can do it in 20 days regardless, but I wanted to flag that issue for the court. And also, I know Mr. Thierman mentioned the declaration from Mr. Schmidt. If he intends to use that as a roadmap, if I could get the date at some point, because I know Mr. Schmidt's filed multiple declarations.
Oh, okay. It's Exhibit 1. It's file stamped 8/31/2020, and transaction number 804-6227. This is the list of, and it's a 2-page document that lists, I think it's titled both pages, issues on claims paid before July 11th, unpaid for weeks July 11th to August 15th. And what I was asking earlier was if you're going to supplement that. I may also rely on the Exhibit 1 filed by Ms. Scott on July 30th, 2020, for notice of the fact that you knew that DETA had notice of the court's order.
All right, so Mr. Ott, did Mr. Thurman answer your question? All right. Now, with respect to the confidentiality, you know, what I think I have here is the petitioner saying that there are multiple of thousands who otherwise should have been encompassed by the court's order that were not timely paid without legal cause. And I'm trying to think of a scenario where you pull out 3 or 7 or 12 examples of why these people were not paid when otherwise it would appear they would have been captured by the order of mandate. I don't believe we need to compromise anyone's personal information in order to do that. I don't need the names. You can call them John Doe 1, Jane Doe 1 if you want to give the court an example that this represents an actual person and a reason why it would have appeared that they should have been captured by the writ of mandate order, but they were not timely paid. And Judge, we have looked in our file, we have 1,800 people who fit in this type of a category. If you have evidence of that, I don't need to know their names or their particular circumstances. So I'm looking more for a 30,000-foot view of compliance as opposed to why certain individuals who otherwise might have been entitled to be paid were not. That doesn't mean I'm completely discounting that your concern might be valid. I'm just, as I sit here right now, I think we can have a hearing and the court can be fully informed without having to drill down too much more closely. But Mr. Rod, did those thoughts help you at all, or is it still of concern to the state?
It is, excuse me, it is of some concern. I think I understand the court's intent is to deal with broad categories of people and you know, people with certain things in common. I think it's going to be challenging to have individual testimony about anyone who says they were fit into one category or the other. So, and I think as I understand the hearing, we'll be telling you this category of people was reviewed and X went into this bucket and X went into that bucket on these sorts of dates. It's going to be, I think, hard for the plaintiff to come up with, I guess, evidence other than that if we're dealing with these broad buckets, because we won't have individual stories. Am I correct in understanding that?
I think the question was directed through the court to Mr. Thurman.
Well, I'm with Your Honor. I mean, to the extent that there's clear and convincing evidence of fraud, it's not revealed by the categories that these people are put in and the reason that their claims are either denied or not being processed. I don't see it, man. I mean, I could stretch and say maybe IP address is a clear and convincing evidence of fraud, although we know it's not. IP addresses are, I found out, are dynamic and can be reassigned at a moment's notice randomly. But other than that, I don't know what would be stretching to be fraud on this list. So unless there's some, I don't need to know whether no employment history is unemployment not a result of disaster or PUA eligibility, etc. To me, those are non-reasons, at least as far as the court's order is concerned. I don't need to know whether these 50 or 100 or 1,000 people who fall in that category, I don't want to know their names. I don't really care. It's not relevant.
Yeah, I don't want to say too much here, but I want to say enough to give the parties an understanding of what the court would expect at a hearing on the issue of whether the state of Nevada is to be found in contempt, and on what grounds and what the remedy would be. If the court's writ of mandate, to the extent it could be specific, address those two buckets of payees that the court believed had not or were not being paid when they ought to have been. And the others I deferred and then later denied the request, which I understand is the subject of the competing appeals. But if the evidence is that the court's order should have grabbed 25 or 30,000 people, and then it turned out that half or a quarter of those were actually paid, either by or very close to the court's deadline, but the other half or 2/3 or 3/4 were not, it will be the state's job to explain to the court why not, and convince the court that that is a justifiable ground so as to defend against a contempt hearing. Now, are we going to get 2,500 or 8,000 or 15,000 different examples of why they weren't paid if that's what the evidence shows? Of course not. Can you give the court sort of top of the column examples of why people were not paid when the court would have expected them to, and then have somebody credibly explain to the court that they stand at the top of the column for another 800 or 1,500 people below them with like circumstances? Well, that may resonate. But I would like a level of detail sufficient to, if the state has the evidence, justify the failure to pay them in accordance with the court's order. I don't know how else to explain that. If you think this is going to be a 2-day hearing, not a 3-hour hearing, we'll get a different 2 days in a row. If you think that you'll need more time than from now to the first week of December to line these things up, tell me now, we'll look for a date later in December. If you think that the Nevada Supreme Court may have an order that is important on the preparation here, or will obviate the need to go forward with such a hearing, or be informative to the court on other grounds, we can talk about waiting a little longer to see what the Nevada Supreme Court does. But right now, there's been a court order granting in part a writ of mandate, and now I've got a petitioner saying the state hasn't complied. And while we had a mutually agreeable stand down, that's over. So with that, Mr. Ott, Mr. Whitney, and Administrator Caffaretta, that's really the best way I can explain the court's view of how the hearing would go on the application. Before I hear additional questions from the state or comments, Mr. Thierman or Ms. Jones, would you like to address the court?
I agree with Your Honor. I think that's it.
Okay, Ms. Jones, any other thoughts from petitioner's side?
No, thank you, Your Honor.
All right, Mr. Whitney, let me start with you. Is that, I know it might be as clear as mud to you, but is it at least partially clear?
Yes, Your Honor. To me, I think it's partially clear. I'd like to hear, though, what maybe Attorney Ott and Attorney Jordan, if there are any questions from up north. But I think I understand the gist of where the court wants. Thank
Okay,
you.
Mr. Ott, I know there's a lot going on there with you, but that's really the best I can explain it right now. But what else would you like the court to know, or any other questions you have for the court?
Well, I appreciate the court's clarification. I guess what I'm thinking through in my mind is between the motion for contempt, which sets out the categories that I guess the petitioners cared about. Those would be the category, because you can slice things into a number of different buckets, and the buckets can have different sizes and whatnot. So I think what I'm hearing is we're not going to be going into confidential information. So we're not going to get individual stories from individual people. So we don't need, 1,000 emails saying something. What you're interested in is the categories of people that petitioners have raised, when those people were paid, or if they were not paid, why they were not paid, the timing of those things, and then the explanation of if the timing wasn't within the court's order, how long that took. I think that's what I'm understanding.
I think that's accurate. I mean, the petitioner may have a handful of individual witnesses to identify their personal stories and try to suggest to the court that they're indicative of others with like experiences. If that may or may not be the evidence, it may or may not be persuasive. So I'm not suggesting you should completely ignore handfuls of examples, but I'm looking for big picture compliance type issues. And now that we've kicked this around a little bit, I'm thinking maybe a full day. We should start at 9 and see how much the day we need rather than half a day. Because there could be a variety of types of evidence, testimony, and argument from the court. So I'm going to try to give you a full day in a minute. All right, before we do that though, I want to talk as well about the special master's billing that was filed in September through August. You'll recall the first request that was granted by the court, $65,000, $66,000 and change. The second one is a bit lower, somewhere in the high 30s. I deferred ruling on that. I've gone back and looked at the reasoning underlying the court's order. In fact, that's one of the reasons I caught the typo this morning and amended. But I think the reasoning justifying an award against the state remains sound. I'm not aware of any jurisprudence that's come out in the last 45 days that would compel from the court's analysis a different approach and as therefore a different result. I believe the master's professional expense was reasonable. I find that it was discounted even from the total amount. And so absent of objection other than what's previously been raised by the state as to apportionment, the court is inclined to issue a order directing the state to be responsible for the entirety of the special master's second billings. Again, something just south of $40,000. Mr. Thierman, I'm aware, has no objection to that because why would he? Mr. Ott, though, if you'd like to put on the record again your reasons why you think that's an unfair allocation, you can certainly do so. Mr. Ott.
So reiterating what we said in the prior briefs, I think that the arguments are largely the same. There's one important distinction that I think the court should be aware of, and that's basically the difference of the activities and the scope of what the special master was doing in the second billing as to the first. My recollection is the second billing was comprised of dealing with the three issues that the court ultimately did not issue writs on. So the activities the special master was dealing with during this billing period we're the prevailing party on. So I think the court should note that in its analysis and take that into consideration before the court makes a ruling. Otherwise, I think that the arguments are largely the same.
Well, thank you. So, Mr. Thierman, I'll let you respond, then I'll give you my thoughts.
I don't think it should make a difference. And I don't know if that is absolutely correct. I think the last part of the last report was how are we going to fix this more than anything else. But it really shouldn't make a difference because this is well, first of all, as we're aware, these are people who are unemployed. They're not going to, there's no way they can pay it. They're under the gun anyway. And I think that the report of the special master was beneficial to the court to make a decision. And we'll see what happens on appeal, whether it stands that those three issues are resolved or upheld. And I do think Mr. Ganasso's hourly rate is extremely reasonable. In fact, maybe too reasonable. So and they did the hours, so I have no qualms with the amounts. Not just because I'm not paying it or my clients are not paying it, because I think it's more than reasonable.
Okay. All right. The court orders the state to pay the full amount of the second billing, notwithstanding the points raised by Mr. Ott on behalf of the state of Nevada. The court adopts the reasoning from its prior order and finds it still to apply and be valid here, even with the second bucket of work that the special master diligently addressed along with his staff. With respect to the ultimate result, and again, we all are aware the court has denied the petition for the writ of mandate on certain issues sought by the petitioner. The court, while that's factually correct, Mr. Ott and Mr. Whitney, the court does not believe that compels a different result with respect to the allocation of the special master's professional expenses. So it will be the order of the court that those as well will be borne by the state, and the deadline for those to be paid will be by the end of this year. The other ones were to be paid by November 15th, and the court believes that if it gives a December 31st deadline to the state, that falls within the timetable the state needs to process that claim. Mr. Ott, do you know any differently?
No, Your Honor. Looking at the Board of Examiners and the Interim Finance Committee schedules, that should be a workable deadline. Thank you.
Thank you. All right, now let's turn to, there was a motion by the petitioner to extend their deadline to make a request for their own professional fees and costs to a point in time after a final judgment or order disposing of the substantive matters in this case had been reached. The state did not oppose that. And then it sort of sat there for a while because the court acts very well if it gets that special piece of paper asking the court to do something known as a request for submission. That was recently reminded to petitioners who then filed that, and the court has granted that request. So the deadline for petitioners, indeed for either party, because it goes in both directions. I don't recall if the order specifically says that, but to the extent it does not, I will extend the deadline for either side to seek a request for fees and costs if they believe there's a legal basis for it, to be the same date, consistent with that order. That's just fundamentally fair. Mr. Ott, with respect to whether the petitioners are indeed a prevailing party, whether the state is a prevailing party, whether it's a tie, I mean, that's a decision the court will make at a later time. But in terms of the date that each side needs to file their request, that's bilateral, and that will apply consistent with the order the court just entered. Okay, Ms. Clerk, do we have a full day available, or can we make a full day available sometime in early to mid-December? If in particularly, I'm willing to move other things around if they are not so weighty. Ms. Clerk.
Sure. Now we have Thursday, December 3rd available all day.
So that's the first week after Thanksgiving, but if that works for the court and if that gives everyone enough time. So I would suggest 20 days for the state from today to respond to the motion to hold the state in contempt, to give the petitioners 15 days thereafter. That would bring the deadline to, no, that would not be enough. I'd say 10 days then for the petitioners to reply to the state, and that would get it in front of the court the week before Thanksgiving, give the court the opportunity to look at that after its trial and be ready to go December 3rd. So let's start with the petitioners. Is that date available, and do you believe that gives you enough time?
This is Leah Jones, Your Honor. Yes.
Okay, Mr. Thierman?
Yeah, I'm nodding very hard, but yes.
Okay,
That's
thank
my
you.
right button.
Mr. Ott, Mr. Whitney, will that give enough time for the state? And would you have availability at that time?
Sorry, I was just looking at my calendar. I think that's enough time for us. And I think my calendar is okay, but Robert, let's make sure that yours is good too.
All right, well, he's all right, Mr. Whitney?
Oh, thank you, Your Honor. Just want to say that date looks great with me. Thank you.
All right. I'm going to direct each of you to jointly contact Ms. DeGaynor when we get closer to the hearing date to talk about the submission of exhibits and evidence. To the extent you can stipulate, it'll make the hearing go faster. If you can get things to her, because she's going to have to put them up on the court screen. We're not going to be as informal as allowing people to share screen. unless the exhibit's been admitted or it's offered and admitted over objection or by stipulation with no objection. So you have to work just like any other evidentiary hearing with my court clerk to work on exhibit submission. With respect to lining your witnesses up, Mr. Ott, please let the state know who you anticipate having to testify. Mr. Thierman, to the extent you're going to have live witnesses, please as well let the state know who your witnesses will be, and then try to coordinate the order so that we can make this hearing, again, as productive as possible and without wasting time unnecessarily, understanding fully the logistics challenges associated with having a hearing like this virtually. All right. Let me start this time with the state. Mr. Ott, Mr. Whitney, anything else you'd like to bring to the court's attention?
I guess the only thing I would add is regarding the meet and confer regarding witnesses and evidence, it might be good for us to have a deadline to do that well in advance. I don't know if the evidence or the witnesses brought by plaintiffs are going to be extensive, but if they are, we might need a good amount of lead time. So,
well, let me make this comment. You know, this date we have picked, I want to keep it. But if we get close and each side says, you know, we're not quite ready, we're going to need a little bit, you can jointly agree, stipulate to move it a week. I don't want to get too close to Christmas if we don't have to. I mean, this is the date that works right now based on the court's availability. But if you need another week or 10 days because things just aren't lining up and there's more information and more evidence needed, I'm not adverse to that. I'm not going to push this into January, however. That's number one. Number two, I'm not going to give either side right now a hard date to contact Mr. Gaynor with exhibits. I'm not going to direct to each of you a hard date to advise the other of your expected witnesses in the expected order. I'll direct that you do so in a professional manner. If either of you believe that the other side is not abiding the court's directive, get a hold of my court clerk and we'll have a short hearing and we'll get to the bottom of it. But I want to make sure everyone has enough time to fully prepare their position so you can inform the court of what the evidence is and what you believe the law as applied to that evidence, what kind of result it should lead to. So I'm not going to give you a date and time, but I'm going to direct that you work it out, failing which I'll get involved, but I really don't want to. Now, let me also say something, Ms. Caffaretta. I want to let you know that I haven't called on you. I'm not intentionally ignoring you to be disrespectful. I know you've done a lot of things. I know you're working hard, and I suspect you have a lot of information you'd like the court to know at the right time. But the right time, if asked by your counsel or examined by Mr. Thierman or Ms. Jones, will be in early December. So please understand that I'm not trying to be unprofessional. All right, that will conclude this hearing. Mr. Thierman, Ms. Jones, anything else the court may have overlooked?
Not that I can think of, Your Honor.
Ms. Jones?
Nothing, Your Honor. Thank you.
You're welcome.
Your Honor, I do want to add one thing for my colleagues. I'm basically tracking along with the court on the macro view of this, so I don't think I'm going to have 30,000 people show up to testify. That's not what this is about. I don't anticipate this. This is not an individual case. It is an order of court, and if you have the similar type of the ability to do the similar type of spreadsheets or charts that you've done so far by Mr. Schmidt's declaration, that pretty much, and maybe some more data to it, it should pretty much do it. And then there's a question of legalities and inferences about why. So I don't even know if we're going to need a whole day.
Well, we're setting it to start at 9 o'clock just to make sure we have enough time. All right, Mr. Ott, Mr. Whitney, anything else?
I would just thank Mr. Thierman for that representation. despite the sometimes contentious nature of this case, I appreciate that. And I'm confident we'll be able to work together to make sure that we have a manageable universe of documents and witnesses that we can agree on. So that guide map is helpful to me.
Well,
Robert?
yeah, Mr. Whitney, final thoughts?
Nothing else really to add, Your Honor. Thank you for this. Thank you.
You're welcome. You know, I'm going to say what's already been said by both sides more than once since the summer when this amended petition was filed and pursued. And that is, this is the rare and somewhat unusual case where all parties essentially want the same result. And that is that people who deserve to and are entitled to be paid benefits are paid as timely as possible and as the law requires. The area of friction, though, here is, you know, whether that has occurred and is occurring and will continue to occur in the future. And that's where the court steps in to provide its oversight, guidance, and ultimate determination on certain issues. But, you know, each side wants really the same thing, and that's people who are in need and are entitled to be paid. So, you know, the court is mindful of that, yet as well, it has a job to do and intends to do it. Okay, with that, thank you all very much. An order will come out with respect to the hearing just now, probably within the next several court days. And other than that, the court will be in recess. Thank you, everyone.
Thank you.